Under the First Amendment, can schools punish students for their lewd and indecent speech? What happens when a student delivers a speech full of sexual innuendos to a required assembly of over 600 of his fellow high school students? How should schools respond when a high school speech sounds more like a late-night comedy set? Jamie?
Oh, this is going to be a fun one. It's our 2-year anniversary, everybody, and we're going to stay true to form and cover another landmark Supreme Court case for you.
Yeah, what happens when we run out of landmark Supreme Court cases?
You know what, Chris? I do not anticipate running out of...
Maybe we just ask the court to decide more cases.
Yeah, we could do that.
I think that would be easier than stopping the show.
Yeah, I'll see. I'll give him a call. See what they say. So this is a case about a student speech at an assembly that went from persuasive to provocative to potentially pornographic.
Some very good alliteration,
Jamie. You like that? There you go. This is the famous Supreme Court case, Bethel versus Fraser, everybody, from 1986. Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, bringing you the fascinating stories, connecting the courtroom to the classroom.
Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
Okay, folks, welcome back. Thank you for joining us again. It's the fall. We've got the Education Law Association's conference coming up in a few weeks in Kansas City. We hope that if you're listening to this show, we hope that you're going to meet us out there. It would be nice to see you. It's a great organization. Chris and I met there. That's where we came up with Chalk and Gavel. So we would love to see you get involved with this great organization. You can go to educationlaw.org to find out more. And if you want to register for the conference, you can do that there as well, and we'll see you there. We're going to try to do an episode recording while we're out there. We're going to try to do some listener questions. You can go ahead and send us any questions you might have. If you want us to look into anything and answer them for you on one of our episodes, send an email to chalkandgavel.com, chalk, A-N-D, gavel, @gmail.com, sorry. You can go on our social media sites. We're at Chalk and Gavel. Our website is chalkandgavel.com. So send us any questions you might have.
Yeah. Look forward to all of that and seeing what you all want to know more about. Also, please like, rate, and review Chalk and Gavel wherever you get your podcast. That's a huge help for us to get us in those algorithms. We also have a teaching guide on our website. If you're looking for ed law content for your classes or professional development, you can find a link to that at chalkandgavel.com. And last but not least, support us on Patreon, because we've been doing this for 2 years, and that's a long time.
That's a long time.
This feels like a real thing now, right?
Yes. This is what we do. Yeah.
So go to patreon.com/chalkandgavel. $2 a month helps us keep the lights on. So Jamie, I think you've got our bell ringer today.
So before we dive into the fun Bethel versus Fraser case here, wanted to give you another little update. The ACLU just filed a federal lawsuit against several Texas school districts for displaying the 10 Commandments in classrooms.
Hey, I know this one.
You do, because we talked about this a little while ago in one of our bell ringers. So if you remember, there is that Texas law that was paused back in August. Chris talked about this a couple episodes ago in one of our bell ringers. But that judge said that the Texas law likely violated the First Amendment's separation of church and state, but that pause only applied to a handful of school districts, right?
Right, because they were the only parties to the case.
Right. Well, other districts, I think there actually might have been some overlap with some districts from the lawsuit, but there were a total of 14 districts that were named in this ACLU lawsuit because they went ahead and displayed the 10 Commandments. So they're
because the
trying
state
to
was telling
follow-
them they needed to, and this court
Yes.
was saying like some districts don't need to.
Exactly.
Yeah.
Yeah. So the ACLU argues that this forces religious doctrine on public school students, and families from multiple faiths are backing the lawsuit. And they're asking the court to stop the enforcement statewide this
Good.
time.
Yeah. Enough of this hodgepodge.
Yeah, exactly.
Right. And given the outcome in the other cases, like this one seems like ACLU's probably got a good foot in the door.
Well, yeah, because we have that Fifth Circuit ruling from Louisiana, I think, that was also
Right.
over the last few months that basically said you can't put the 10 Commandments up in the classrooms.
Right. Yeah. We did an
So-
entire episode on that one.
Yeah, this is the gift that keeps on giving. This is one of the many issues
Right.
that has become a gift that keeps on giving to Chalk
Right.
and Gavel.
Speaking of joking about never running out of things to talk about.
Yeah. All right. So that's that. We'll, of course, keep you posted. Okay. You ready?
I'm excited for this one. This is another one of my like
I
top
know.
5, maybe top 10
We've
Supreme
been
Court
waiting
cases.
to do this one for a long time. We've
We've mentioned
about
it
this.
so
Yeah.
many times.
I know. So here we go. All right. So back in our first anniversary show, we did Morse versus Frederick. That was a landmark student speech case, Supreme Court. That was the Bong Hits for Jesus case. And to celebrate our second year of Chalk and Gavel, let's talk about Bethel versus Fraser. Let's finally do it. And you know what's funny, Chris? Bethel versus Fraser just doesn't have like a fun moniker like these other ones do, right? Like you got Bong Hits for Jesus.
Right.
You got
Which
the
is
cussing
great.
cheerleader case, right? For the Mahanoy
Yeah.
case, the black armband, that's
Tinker.
the Tinker case,
Yeah.
right? But
you're
always
right.
we call this, it's the Bethel versus Fraser case. That's
Right.
boring, man.
That is boring. Yeah, because all these other cases have fun little monikers, right?
And this, like, if there's any case that should have a fun moniker, it's this one.
Right. Yeah. Like the fact pattern in this one, I don't know, like Bong Hits for Jesus is nonsensical and kind of hilarious, but like this one is just clever. Like,
Well,
I want to be friends with Fraser.
I mean, he's got a good sense of humor.
Or he did in 1982. Not
Yeah,
sure what he's
yeah,
up to
yeah.
today.
Yeah. So this was 1982 when all this happened. It was 1986 when the ruling came out and everything. But
But yeah, we need a name for it.
let's do it. Let's come up with it. Okay, so just the really quick overview here, just so that you know where we're going with this audience. This is a case about a student speech at an assembly that was it crossed the line as far as
Or
vulgarity.
did it.
Yeah, that's what we're here to talk about today. So we're gonna tell you about the speech. We're gonna even read the speech.
Jamie's going to do another dramatic interpretation, I think.
So we're trying to come up with a fun moniker that has to do with a student speech that was potentially crossed the line into vulgar territory here. So
There's
let's come
one.
up with some ideas. What vulgar?
The
Territory?
vulgar valedictorian.
Oh, vulgar valedictorian, right? Because he did speak at graduation.
Yeah, I don't know if he
Ultimately.
graduated first in his class, but he spoke at graduation.
Yeah. So vulgar valedictorian case. That's a good one. Let's see. What else could we come up with here? Suggestive speech case.
It
'Cause
is
there's-
very suggestive.
that
Speech,
kinda
though,
seems-
doesn't work very well because it's all speech, but this
Yeah.
is a speech. Yeah.
Yeah. The fits and spurts case, because that was a direct
I was
quote.
going to say that's a direct quote from the speech, I think, right?
Yeah.
Yeah.
That's kind of gross.
Yeah. No. Frisky
What do you-
Fraser?
Frisky Fraser.
The Frisky Fraser case.
Nice. That's, oh, you know what? That's good. How about the PG-13 Pep-Rally?
I actually kind of really like that.
You like that?
Yeah. Let's do the case and we can let those percolate. And
Oh,
maybe
yeah,
that'll
and
be
if-
the homework.
Yeah, that's the homework, everybody. Pick a
Tell
fun
us which one-
moniker.
Yeah.
Yeah.
Come up with a good moniker.
Okay, here we go. Ready? So this whole thing started in the early 80s in Pierce County, Washington. All right. So this is about 14 years after Tinker versus Des Moines. That case was decided in 69. And like in Morse versus Frederick, Tinker looms large in this case as well, which is why we mention it.
Right. Yeah.
Okay.
Because Bethel
Tinker's
versus
the
Fraser.
standard.
Right.
right?
And this is the case that came after that. So there's
Yes.
no student speech cases between Bethel
Right.
versus
right.
Fraser and
Right.
Tinker.
Right. So when this thing gets to the court, that's what they look at. They go back to the Tinker standard because that is the only standard essentially at this point.
Right.
So here's the deal. We've got our plaintiff, Matthew Fraser. He was 17 years old. He was a senior at Bethel High School. On April 26th, 1983, Fraser delivered a speech at a school assembly in front of about 600 high school students. Okay? These high school students ranged in age from about 14 to 18, as most high school students do. Okay? And so the speech was all about, they were doing nominations for their student government positions. Right?
Okay. So this is political speech, right? This is pure political speech.
Pure political speech. They are nominating folks for student government positions, and people were getting up there and giving speeches in support of their preferred candidate. Okay? Now, the court here is very clear that this speech was delivered as a, quote, part of a school-sponsored educational program in self-government, unquote, and that students were required to attend. So this is a mandatory event for students, okay? It's a school-sponsored educational program, so it's essentially a part of the curriculum, okay? And the program is all about self-governance.
Right. And that captive audience piece, I think, is really important. Like, students were forced to be here to listen to these speakers.
Yes, there is nothing optional about this. Okay, so how did this case become a case? What did Fraser say?
I think that's at the heart of this.
Exactly. So this is one of these things that we've talked about where context is everything. And interestingly, the actual text of Fraser's speech is missing from the majority opinion in this case. How do you take that out? How do you not put that in?
It boggles my mind that, like, that's the thing we're talking about and it's not there. Because that came up in another one of our cases, right?
Yes, it did.
Evans, right?
Yes, the Evans versus Hawes case, yeah.
Right, yeah. Like, if you're going to decide a case based on something that somebody said, please tell me what they said.
Exactly. I do not understand it. So instead of including the actual language from the case, the majority opinion calls Fraser's speech, quote, an elaborate, graphic, and explicit sexual metaphor, unquote. Well, yeah. You're gonna
elaborate, graphic, sure. Explicit?
It wasn't really that explicit. It was implicit.
This is the 1980s, so we're talking like 50 years ago.
Dude.
Jamie, what was that? I'm sorry. I'm so sorry.
It wasn't 50 years ago.
My math's not great.
It's 40-something years ago.
83?
83.
Yeah, okay. You're right.
Yeah.
Not quite 50.
Yeah, that's right. Yeah. Somebody else here is not quite 50.
I think I struck a nerve. I'm sorry.
Okay. So it also describes the speech as, quote, obscene, vulgar, and lewd. And in another portion of the opinion, it says offensively lewd.
I love that because that implies that there's a category of lewd that is not offensive.
Oh,
right. So it's inoffensively lewd.
Yeah. That's a perfectly fine lewd.
Right. Yeah.
I don't know. I
don't think that's
if
what
you're going to be
mind,
lewd.
But
if you're going to be lewd, you might as well be offensively lewd because what's the point?
Right.
Okay. So for his part, Fraser shared drafts of his speech with two teachers beforehand. Okay. Good start.
Probably a good idea.
I would like to show you what I'm going to say. And I guess he was honest about, what he was going to say because those two teachers said, nah, that's inappropriate. And chances are you're going to get in trouble if you deliver that.
He didn't listen, I think.
Oh, no, he did not, which is why we're here.
Good. Kind of getting Frederick vibes, right?
Yeah. He's like, I want to push it and I want to see how far I can.
Yeah.
All right.
Yeah.
And
good for him.
Yeah. Our listeners are like, would you just read the darn speech already?
I know.
Like, come on. Like
how long can we drag this out? We're like the majority opinion over here.
I know, exactly. But it is, the point is like, it's really annoying that they're using all these terms to define the speech at hand here, the speech in question, and they're not including the speech in question.
Right. Yeah.
Just take our word for it. This thing was awful.
Right. Which is one of the things that one of the concurring justices actually like takes them to task for. And it's like, are we talking about the same thing here, guys?
Yeah. Which I guess has come up a number of times in Supreme Court cases. Go back and listen to our Kennedy versus Bremerton one. Are we really talking about the same set of facts?
Right.
Anyway.
Yeah.
Okay. So are you ready? Like, should we just go ahead
ready.
and let's do the speech.
Rip off the Band-Aid.
I'm going to give you what was offensively lewd according to 1980s Supreme Court standards. All right. I will say it is a little bit more colorful. The language is a little bit more colorful than what we typically deliver here on the show.
No swears.
No swears. A lot of implied innuendo.
Would you call it a prolonged sexual metaphor?
Okay. Yeah. I can get on board with that. So if that's something that makes you a little queasy, folks, you can skip ahead a little bit. But if not, here we go.
I want the dramatic reading, Jamie. Give it to me.
I'll do my best. We don't have a recording of this from the actual event. I think if this took place nowadays, you'd have cell phone video all over the place of this. But anyway, here is the speech that was given at a attendance required assembly in front of 600 14 to 18-year-olds. Here we go. I know a man who is firm. He's firm in his pants. He's firm in his shirt. His character is firm. But most of all, his belief in you, the students of Bethel, is firm. Jeff Coleman is a man who takes his point and pounds it in. If necessary, he'll take an issue and nail it to the wall. He doesn't attack things in spurts. He drives hard, pushing and pushing until finally he succeeds. Jeff is a man who will go to the very end, even the climax, for each and every one of you. So vote for Jeff for ASB Vice President. He'll never come between you and the best our high school can be.
That's persuasive.
You like that? Would you vote for Jeff? I'd vote for Jeff.
I'm going to vote for Jeff. Yeah. So, obviously there's innuendo, right?
Yeah.
Like it's all innuendo.
Yes.
But it's not, I don't know how offensive it is.
I mean, offensive. Yeah. I don't know how offensive it is either. I mean, you could easily say it was clearly suggestive.
For sure. Yes.
Anybody with half a brain can hear that and go, I get what that guy's trying to do.
For sure.
Right?
What if we called this the vote for Jeff case?
Oh,
I kind of like that.
Okay, yeah. That could work. Yeah. Okay. So listen, Fraser delivers this speech against the advice of those two teachers who said, probably not a good idea.
In a room full of teenagers.
Yeah. And so I think we can all guess how this was received by those school administrators in that room.
And the teenagers. I've known some teenagers in my day.
Oh, yeah. I would think there was some good laughing going on.
At least.
In there. Yeah.
Yeah.
And I wouldn't be surprised if there were some teachers off to the side kind of giggling behind there.
I would chuckle.
It's bold. And anyway, so a school counselor who was observing the assembly said that some students hooted and yelled. Okay. Some students gestured and graphically simulated the sexual activities alluded to in the speech. Okay. Again, we're dealing with high schoolers, not surprised. And others appeared to be bewildered and embarrassed.
Right.
It takes all kinds.
About this. If you get it, you get it. If you don't get it, you're like, I don't, why? What is this?
What's going on?
Right.
I'm offended. So other than, the assembly there, the record is pretty sparse about any other kinds of impacts that this speech might have had on the school. The day after the speech, one teacher reported that she had to dedicate part of one of her classes to discuss the speech with the class. But there's not a lot other than that. Yeah, go ahead.
Really matters. That really matters because at this point, all we've got is Tinker,
which is the disruption standard.
Yeah, the material and substantial disruption standard.
Right.
And so that was kind of the green light that Tinker gave for when you can censor students' speech. Here, that if that's the only disruption, is that a material and substantial disruption? It doesn't sound like it because this is the exact kind of disruption that the school claimed in Tinker that wasn't enough.
Yes.
Right? One class got disrupted where you had to kind of talk about the incident.
Talk about the issue, yeah.
And that was a de minimis or it wasn't material and substantial. So here, if I'm
using the
Fraser, I'm feeling pretty good because
I didn't material and substantially disrupt the school. It was all limited to that assembly. There was no report in there that it said that they couldn't get control over everybody else after the assembly after the speech was given. Like
right. It sounded like it just kind of went on.
It happened.
Okay, next speaker.
Right.
Right.
So
the school had read Tinker and was like, we probably can't do anything here because we don't have a material and substantial disruption, and everyone went home.
No.
Yeah.
No. So Bethel High School has a rule in their code of conduct that says conduct which materially and substantially interferes with the educational process is prohibited, including the use of obscene, profane language or gestures. That's not Tinker.
So they added. So wait, how would obscene, profane language or gestures interfere with the educational process?
Well, it doesn't say in their school handbook and their code of conduct. It doesn't link the two. It just says things that interfere with the educational process includes obscene, profane language and gesters.
I'm just questioning how you put that into that bucket. Right.
Well,
like
somebody,
to me, it just feels like a tack on. Like,
do it.
yeah. Right.
That's pretty much it. The court in Tinker didn't advise that.
Right.
So
yeah, some school leader was probably just like, you know what?
Let's throw that in there.
Yeah.
So the morning after the assembly, the assistant principal called Fraser into her office and told him that he violated that rule, which was a rule against obscene speech. She gave him 5 letters from teachers who were at the assembly and gave him a chance to explain himself.
Okay, good. So he got due process. That's exciting.
He's getting due process. He admitted to giving the speech and acknowledged that he used sexual metaphors on purpose. Now, side note.
As opposed to right? Incidental innuendo, right?
Oh, I had no idea. That's what that meant.
Really?
Really? I said what?
That would have been a really good defense, though. Like, no, that was sincere. I didn't realize that there were sexual overtones to what I said. It's interesting that you brought that to what I said.
Yeah. Anyway, so he admitted to all of that, and the assistant principal suspended him for 3 days. Okay? And there's more. She removed his name from the candidates to speak at graduation.
Ooh.
Yeah,
I mean, if there's one thing we know about Fraser, he's a good public speaker.
He is a good public speaker. Yes. So they have speakers that they will invite for graduation ceremonies and things like that. And so she removed his name. Suspended for 3 days, and you're off the list for graduation. Okay. So he appealed his suspension through the district's grievance process, right? But was unsuccessful in that regard. He served 2 days of his suspension, but was allowed to return to school on the 3rd day. Okay. So he ended
2 days
up,
suspension, can't speak at graduation.
Right. That's what he ended up with. He was not satisfied by that. So what did he do, Chris?
Well, like all of our students who are pushing the bounds of the First Amendment, he brought a lawsuit.
Excellent. And how did that go for him?
Really well until it didn't.
Oh, okay. Yes. I was wondering where you went with that because.
So he sues the school in federal court, alleging, among other things, that the school violated his First Amendment right to freedom of speech, which, Jamie, makes sense to me. We've kind of already talked about it. Like, all we've got at this point from the Supreme Court is Tinker. Tinker said material and substantial disruption.
Right.
Doesn't seem like there's a material and substantial disruption here. So let's roll the dice and see what happens.
Okay.
And I kind of already joked about this, but he does win at the trial court. The trial court holds for Fraser. And so the district court concluded that the school violated Fraser's right to free speech. They also found that the disruptive conduct rule was unconstitutionally vague and overbroad. Basically, it didn't give enough notice about what was not allowed.
Okay. Interesting.
Yep.
All right.
And this is my favorite part about the district court opinion. The opinion also found that there was no notice that being forbidden to speak at graduation could be a punishment. And so that punishment was inappropriate.
And interesting.
So the court stopped the school from forbidding Fraser from speaking at graduation.
Oh, that's interesting. Now, just as a little side note, everybody, this is one of the reasons why we say in your handbooks and things like that, make sure that the consequences for specific infractions are very clearly laid out so that people know not only what they could get in trouble for, but what kinds of trouble they could get in.
Right.
When they when they break those rules or whatever.
Right.
Be very, very clear. So that's interesting that the court said that.
Right. And, the Supreme Court ultimately doesn't pick up on that. Like they don't, they kind of say like, schools have a lot of discretion, so you've got leeway, but it helps strengthen those arguments like, well, no, you were on notice if that stuff is in there.
Exactly.
So, so the trial court forbids the district from preventing Fraser from speaking at graduation. Fraser had actually won the vote from his students to speak at graduation as a write-in candidate, because this was all going on when he wasn't allowed. So his entire student body goes against the principal and says like, no, we want Fraser. So this is the, what is it? The Streisand effect, right? Like you prevented him from speaking, and by preventing him from speaking, it led to him having a larger platform.
Awesome.
Right? Like, I love it. Anyway,
here's the big unanswered question. Did Jeff win the election or not?
I don't know. We should look into that. Yeah. Because like it was an effective speech.
Yeah.
So Fraser delivers the commencement speech on June 8th, 1983, because the trial court essentially said, you can't stop him.
Yeah. Okay. So the whole trial court decision happened within enough time for him to that year to be able to deliver that speech. So that's great.
Right.
Okay.
Yeah.
Great.
So Bethel Fraser's probably feeling pretty good. Bethel High School probably not happy with that outcome. So they appeal the trial court's decision to the Ninth Circuit Court of Appeals.
Yeah.
And the school loses again.
Hey, they're 0 for 2.
0 for 2. The Ninth Circuit found Fraser's speech to be indistinguishable from the protest armbands and Tinker.
Wow.
For the Ninth Circuit, there was no material and substantial disruption. They weren't convinced by the school's argument.
That's indistinguishable from the armband thing. I don't know if I would go as far as saying it's indistinguishable.
Well, there's so many different things to distinguish them. Like, captive audience, right? Like the school-sponsored nature of the assembly.
The message that it's giving or the message that it's sending is...
Right. But, so it's not like pure political speech but it's in a political forum, right? And so like it's political speech with like a little bit extra.
Right.
So maybe not indistinguishable, but hey, the Ninth Circuit was like, these two things are close enough. We're not going to treat them differently.
Okay.
And the school was also arguing that they needed the authority to basically be able to protect students from lewd and indecent language because that captive audience issue that we just kind of talked about. But according to this Ninth Circuit, they didn't kind of buy that because they said that giving schools unbridled discretion to determine what is decent, like that's going a bridge too far. Because that would give schools a ton of authority over what students say and kind of how they say it. And there's cultural expectations around that and lots of other concerns that hey, maybe that's something that if we want to protect student speech, like that might be giving them too much authority.
Yeah. Exactly.
So Fraser, 2-0. Unfortunately, the school appeals to the Supreme Court.
Okay, here we go.
And, the school is probably thinking like, hey, if at first you don't succeed, appeal to the Supreme Court. Because guess what?
They took it up.
And the school finally wins.
Yep.
So in a 7-2 decision with a couple of concurrences and 2 dissents that we'll talk about, the Supreme Court sides with the school upholding the discipline of Fraser. And this is obviously after he spoke at graduation.
Yeah. And this is, like you've said before, even though the school lost 2 times before this, and they were 0-2. Once you get to the Supreme Court, nothing else matters, right? Like you have said, you have said this in the past. They may not always be right, but they're last.
Yep.
Okay.
Yeah. And their word goes, right? Like this is now the law of the land that we're going to talk about here in a second.
So why did they rule in favor of the school?
Basically, they kind of just disagreed with what the Ninth Circuit said. They didn't
they said it was disruptive?
No. They create a carve out to Tinker. Another ground under which schools can discipline student speech. So maybe it's not a carve out. Maybe it's just another bucket of student speech that is punishable by schools.
Yeah. And so like the way I usually describe this when I'm talking about these kinds of things in my classes is that, over time, this is what happens when, if you take a an issue like student speech or really any other issue, a court will rule on a very narrow set of circumstances regarding that issue the first time around, and it will sort of establish some goalposts. Another issue will come up that is in that same ballpark, but might have some, slightly different facts. And the court will either say these facts aren't really all that different and the old rule still applies, or they'll say, you know what, there is a little bit of a difference here, and we're going to add something to this rule that exists already. Sometimes we call them carve-outs. Sometimes we call them, additions or whatever. And then the goalposts become more clearly defined around an issue. Right. The more cases that pile up, dealing with that issue. Your
precedent starts looking like Swiss cheese.
Yeah, exactly. So what you're saying here is the Supreme Court took the student speech standard that we have from Tinker and added to it. So now
added another consideration. Yep.
Yeah, there are other things that we have to consider. So what are those things, Chris?
That's a good question. So the question before the court, you have so many good questions, James. The question before the court is whether or not the First Amendment prevents the school from disciplining a high school student for giving a lewd speech at a high school assembly. And the way the court describes the speech, I think, is really telling because they call it lewd, indecent, offensively lewd, right? And so all of that kind of gives us a clue on where this is going.
Yeah.
But, the court starts with Tinker. Tinker said students don't shed their right to freedom of speech at the schoolhouse gate.
It's very interesting, though, that they use offensively lewd when the court has repeatedly said that something that is offensive is not enough to suppress that speech.
Right.
Like,
and there's a couple really interesting contradictions here, right? Because that was a big part of Tinker was just because some people find it offensive doesn't mean you can prohibit it, because the First Amendment protects that speech. And that's a huge part of ensuring kind of the self-government purpose of the First Amendment is making sure that everyone is heard within these forums. Right. And the court kind of flips that on its head a little bit, because it says that schools one of their purposes is to prepare students for citizenship. And part of preparing them for citizenship is inculcating and teaching them the habits and manners of civility. So that's kind of where the court is coming from. They're saying we need to prepare students for self-government. Absolutely. 100% on board with that. Right. But they say part of that, though, is knowing how to engage in these conversations. So it's not what you're saying is unpopular. It's how you're saying it is inappropriate. Mm-hmm. And that's the line that the Supreme Court is drawing here. So, there's this quote from the Supreme Court. The court says, quote, "These fundamental values of habits and manners of civility essential to a democratic society must, of course, include tolerance of divergent political and religious views." Jamie, that's kind of what you were talking about. Even when those views expressed may be unpopular. Right. But those fundamental values must also take into account consideration of the sensibilities of others, and in the case of a school, the sensibilities of fellow students. So it's not necessarily a what you said, it's a how you said it kind of thing.
And who you said it to.
And who you said it to, because we've got these impressionable students who, maybe want to protect their innocence a little bit.
Well, and I will say, just on that note, it's important to acknowledge that, as most of us know very well, the developmental stage that an 18-year-old is at is very different than that of a 14-year-old in many cases. So there is a spectrum there in terms of your audience, right?
Right. And I think everything the court is saying makes a ton of sense. The concern, though, that I have is this tone policing that can go on. And it just seems to allow a little bit too much flexibility, if you will, about choosing whose voices are appropriate or acceptable and all of that. So that's kind of I agree that it has to be a balancing thing. I don't know if the Supreme Court balances it exactly right, but the school context is the thing shaping all of this, right? Because there's a 1971 case that the Supreme Court has to distinguish. So this is a really interesting case. It's Cohen versus California. And it gave the court some trouble here because in that case, in a 5-4 decision, the Supreme Court said it was unconstitutional to prohibit a 19-year-old, so not much older than our kiddos in this case, from wearing a jacket that said F the draft. Obviously, it used the actual word. And they said, California, you can't punish this individual for wearing a jacket, even though you obviously don't like the fact that it has the F word in it.
Interesting.
Because according to the justices in that case, quote, one man's vulgarity is another's lyric. Which is a good line. That's a good line, right?
That's a good line.
So, the court has to distinguish Cohen because of if you can say that outside of school, then, none of this stuff even gets close to that level.
Yeah.
But the school just basically says, or the court basically just says, schools are different. It's their function to prepare students for life. Students have to go to school, right? They're compelled to be there. The age of maturity isn't quite there yet.
That's not an unreasonable...
Right.
I get
it's
it.
a valid distinction, I think.
Yeah.
Right?
I completely. Yeah.
Right. So, even though this might not be prescribable if it happened outside of school, because it's in school,
right,
that changes the calculus.
Right.
And so because of these interests, the court concludes, quote, the First Amendment does not prevent the school officials from determining that to permit vulgar and lewd speech, such as Fraser's, would undermine the school's basic educational mission. And that's the rule of Bethel versus Fraser. Schools have the authority to silence vulgar and lewd speech. And generally, Jamie, we've kind of already alluded to, generally I agree with that.
I do too. I mean, I get it.
I get it, right?
Yeah.
But the question is where do you draw the line? And that's this is a line drawing case, right? It's really hard to draw the line for the exact same reason that the court has struggled with defining obscenity. What is obscenity?
Exactly.
I don't know. I know it when I see it. Right? That's a famous line from a Supreme Court opinion. I don't know what it is, but I know it when I see it.
Right. Right.
And the way the court does this, though, is they kind of say the school has a valid educational objective in teaching civility.
Yeah.
And this violates that objective. So basically this speech contradicts the school's desired educational goal. And that could be read really, really broadly, right? Because basically you could say anytime the school says that what you're saying violates our educational mission, we can silence you.
Yeah. Yeah.
And that's actually
dangerous territory.
That's very dangerous territory because then it's not about disrupting the process of schooling. It's about disrupting the content of schooling.
Right.
Right. And then now we get into issues about indoctrination and all of these other things.
Mm-hmm.
And interestingly, that's kind of one of the arguments made by the school in Morse versus Frederick. They're saying hey, it's our educational mission to protect our students from illegal drug use. Bong Hits for Jesus disrupted that educational mission. So therefore we should be able to punish it.
Right.
And the Supreme Court is very clear, we are not reading Bethel to be that broad. So actually the Supreme Court curtails the meaning of Bethel in Morse v. Frederick. So it just means lewd and indecent speech can be punished.
Yeah. Yeah. Wow.
Yeah. It's a fun case, right?
I love this one. It's a great one to talk about. The speech is always fun to present.
I liked your reading of it.
Oh, thank you. I have no idea how close to accurate it was in terms of
it was more subdued than it wasn't rabble rousing.
Well,
it was more subdued. I like that delivery. I like that choice.
Thank you. I appreciate it. I might deliver it differently if I was standing up in front of a room of 600 14 to 18-year-olds. And I was 17 at the time. I might deliver it differently. Yeah. So this, again, landmark Supreme Court case here, 1980, mid-80s is when the decision came out. So now on Chalk and Gavel, we have covered the 4 big speech cases.
Pure speech cases.
Pure student speech cases. So Tinker was the first one, not the first one we covered, but if we're going to go in chronological order.
We did not cover these in any kind of order.
No, we actually went last first because we did Mahanoy our third episode.
We didn't even work backwards though. Because we did Mahanoy, then Morse, then Tinker, now Bethel.
This is a very meticulously
researched and planned. This is
show.
Right. Tinker, Bethel, and then
Morse versus Frederick.
And then
was the early
Mahanoy.
2000s, and then Mahanoy was a few years ago.
And then we'll have to cover Hazelwood too. But that's a
right.
Sorry,
that's the other one.
speech.
Yeah, school
right. So that's a different category.
That's the other one. Yeah. But it's still a student speech case, and it's the one. It's one that is often grouped with all of these others.
Right, because it's a different category than Tinker's speech, right? And then we talk about buckets, right?
Yeah, exactly.
Yeah. But before we wrap up, I do want to talk about the other opinions in this case.
Okay.
Because this was a 7-2 decision. There were a number of other opinions.
Okay.
And so Justice Brennan concurs in the decision, and he's the one who actually gives us the text of the speech. Thank you. Thanks, you, Justice Brennan.
Yeah.
Because I think it's important. And he jokes, he's like, are we talking about the same thing? Because calling this lewd, like that, this doesn't get there. But he still agrees that the school was authorized to punish Fraser here, but he focused instead on kind of like the decorum aspect of it. So making sure that things went in an orderly manner.
Oh, yeah.
So like for him, like, hey,
it was more about the disruption piece.
Right. Yeah, exactly. Yeah. And then Thurgood Marshall dissented from this. He was one of the two justices who would have found for the student. He agreed with Brennan's kind of principle, but he would have drawn the line differently and basically said like, hey, Fraser's speech here didn't lead to enough disruption.
Yeah.
It didn't cross that line. No harm, no foul.
Yeah.
And now Justice Stevens also dissents. And his dissent starts with one of my favorite opening lines in a Supreme Court opinion. You ready?
Mm-hmm. Yeah. Bring it.
The opening line is, frankly, my dear, I don't give a damn.
Really?
Yeah.
Wow.
And the point he's making is like, hey, that was like
no
when
big deal.
I think Clark Gable said that in not Gone with the Wind, Casablanca.
Casablanca. Yeah.
That was a big deal when like, oh my gosh, he said the D word.
Yeah. Yeah.
Right. And so Stevens is basically saying like, look, this idea of decorum is fluid. It's subjective.
Yeah.
And that fluidity and subjectivity leads to the potential for abuse. And so we need to have clear notice of what the rules mean so that people can follow the rules. And he's basically saying like, if you're going to punish him, he needs to know what he can or can't do. And so Stevens articulates this really strong presumption in favor of free exercise. And he says that because of this presumption, schools do have the authority to promote appropriate speech. They just have to be clear about what speech is or is not allowed. Okay. And so Stevens, harps on that due process argument a little bit more that the majority just kind of dismisses out of hand. But, that's a dissent. I just wanted to bring it up because of the fact that he starts his opinion with a Casablanca quote. Made me happy.
Yeah. It's nice when we throw the movie quotes in there. Yeah.
I agree.
Awesome. We've done Bethel versus Fraser now, the PG-13 Pep-Rally, or whatever you would like to call it. Please send in your suggestions.
Right. And your homework is to come up with a fun moniker for Bethel versus Fraser.
Yeah. And we're going to hopefully just keep pushing it. And at some point, maybe it'll stick.
Yeah, we're going to shape the zeitgeist.
Yeah. All right. So your homework is to join us in shaping the zeitgeist.
Yeah. Yeah, we haven't used our platform for that kind of social engineering yet. I'm excited to see how that goes.
Well, we're 2 years into this thing. Let's get it started. All right. What's the rest of our homework, sir?
The rest of your homework is to find Chalk and Gavel wherever you get your podcasts, like, rate, review, subscribe. If you could leave reviews, like that is such a huge piece because that gets picked up on our engagement metrics and all that fun stuff that we are learning about. You can also go to Chalk and Gavel, find us on social media at Chalk and Gavel. We've got our teaching guide. Support us on Patreon. The last 2 years have been such an absolute blast, and sharing it with all of you and hearing from all of you about, engaging with these episodes, with these cases, with Jamie and I, talking to you all about how you've used these in your classes. Like, it has been such a fulfilling experience.
Yeah.
And we're so excited to share it with all of you. We look forward to continuing it. So your support means the world to us. Please consider supporting.
Thank you. Yes, that's well said. All right, folks, that does it for another episode. We'll see you again in 2 weeks. Have a good one.